This next panel, International Services, the Role of the Lawyer and the Visa Officer, was designed to let us know how we're going to carry on business overseas. Overseas is Buffalo and everywhere else, I imagine. The idea is to see who the players are and to hear what the issues are and to try to figure out how it is that we're going to continue with this partnership. I asked for the privileges of introducing our panelists, including Cecil Rotenberg, who recently described himself as both the godfather and the godmother of immigration.
That was Kenny Zeifman.
I can't think of anyone who understands more the interplay between the visa officer and the lawyer, who's probably done more in case law to define that role and has shaped the current regulations and probably the new ones to come. Than Cecil. On Cecil's panel is Doreen Steidle. If you go back to tab 1, which is our Bible for today, Doreen appears in the renewal bulletin as the Director General of Selection. So Doreen is responsible for developing the policy and developing the programs for the selection of immigrants to Canada, temporary workers. I mean, I guess all roads lead to Doreen at the end of the day.
In my mind, anyway.
Okay. And Charles Godfrey is with us. Any of us who have processed around the world remember Charles in Hong Kong and, I don't know, Charles, you go back a long way, so.
Too long.
San Francisco before they closed it. And
Delhi.
everywhere you've gone, they've closed it down or one.
Not quite.
Charles, I guess this is the end of the Law Society's CLE programs with you here. Actually, Charles is one of us in the sense that he holds an LLB and can spell mandamus and understands how we're going to use it. So he's usually in the top 5 of my phone calls before I get down to the finer points, and I think he'll be a welcome addition to your new group. So I turn it over to Cecil. There's some correspondence inside the binder from Cecil to the international section. If you want to know where Cecil's coming from, just read the binder. And there's Cecil. Thank you.
Well, my name is Murray Oppertshauser. Today we're going to talk about service standards and a little bit more. But I want to give you an apology in advance because of the vast and changing situation in Ottawa as to who is who and what is what and what people are responsible for. Has placed a very large onus on the participants today to try to answer some of the questions that I've raised. Some of the questions that I will raise, of course, are things that are still in transit, as it were, and undecided. So on top of that, the fax that I sent Wednesday got no reply because both parties were away from their desks on Thursday and Friday attending reorganizations. So this is the kind of milieu in which we have to discuss some very important issues. The visa officers here, important ones, say that please don't take what they say as being the gospel because nothing probably has been decided. We are raising these issues more to air them and to try to get a response than trying to supply an answer. I have to tell you the service standards, which Doreen is going to talk a bit for a moment, are important. And I'm reminded back in July 1973, when I went to Hong Kong after the closure of the now famous Nile Rule, Section 34. I went to Hong Kong in 1973 and I took an appointment at the Commission for Canada in Hong Kong. And I really forget the officer who was there. He was Joe Freeman's assistant, number 2. And I told him, guess what? I'm coming here. I'm going to help you. They threw me out of the office and told me that I was not necessary. Little did they know. Doreen, do you want to talk a bit about the service standards?
Sure. Let me introduce myself first because you didn't receive the biographical register annotation with my information in it, which is also in a fax on Wednesday. I've been doing this job as a Foreign Service Officer for 19 years, and I've had postings in Sydney and Washington, in Damascus, in Manila, and in Seoul. So I bring a lot of experience to the table in terms of foreign relations and relationships with lawyers and consultants abroad. I just came back from Damascus in August. Damascus is a hub and spoke, which is a new kind of office responsible for 5 countries in the Middle East. When I came back to Ottawa, rather than assuming a job, I was actually put in on a team for 6 weeks reorganizing headquarters. Now you're going to say, well, what difference does that make? How does that affect us? Well, it does actually quite dramatically. You still have an international region in headquarters that you will be dealing with for overseas cases, but you have now a selection service line which combines the policy on selection with program delivery and with program design and with procedures. So in doing so, in combining these areas into one selection service line, for the first time, the people who design the policy design the procedures. And that should go a long way to addressing a lot of the anomalies that you see nationally and internationally. You'll often see procedures nationally one thing, procedures internationally something else. And that's because they've been designed by two different sets of groups in the department. We're going to bring them all under the same roof, and we hope to resolve any anomalies. So if you find that there are some things that are going on nationally and completely different instructions internationally, please let us know in selection. This only happened November 15th, so a lot of the questions that you'll be raising today, I don't know the answer to, but I'll try my best.
You also want to tell us, Doreen, as to whether or not the medical department comes under your wing?
I have a division in the selection service line that's responsible for developing medical inadmissibility policy. This is something new that's coming. It's not the people, you might not like it, it's not the people who are doing the medical assessments. We have something new in the organization as of November 15th called the Departmental Delivery Network. So all areas in the department which are not geographically defined, for example, CPC Vegreville, the Query Response Center, the Canadian Warrant Center, all the doctors doing North American medical processing, all come under the tent of Departmental Delivery Network. So if the idea is to provide a focus and to provide accountability for someone who can say, there's a problem with processing, we have to get medicals through for North America faster, what do we do? Somebody who looks at the big picture and not just the microcosm. So those doctors that you're talking about that may have had the backlogs in the past come under the Departmental Delivery Network and not selection. There you go.
Thank you.
I wanted to walk you through the chapter in your binder on service standards on representations. This is a telex that's gone out to all posts. You only have part 2. You should have part 1 as well. It says virtually the same thing. It's just in a different format. Okay? Over the years, I think there's been a recognition that case processing involves two partners. One is the client, one is the visa officer. But in between, and as an advocate for the client, and often sometimes an apologist for the visa officer, we have the lawyer. And this is a difficult position that you are in, and it's difficult for us sometimes in dealing with you and your client. So in order to set out standards that we think that we can meet reasonably, which allows us to commit ourselves to a certain level of quality service. We've developed these service standards in conjunction with members of the bar and having consulted widely throughout Canada. A lot of it will sound to you like common sense, and it is common sense. In every post that I've been in, we've applied these standards fairly and consistently using common sense. The problem is that in many posts, as we know, unless something comes from headquarters, somebody might not use their initiative and do something. So what we've decided is to send out very strict guidelines from headquarters on the responsibility that a visa officer has to a lawyer and has to a client. So the very first one is acknowledgement of receipt. If somebody submits an application, we are obliged to acknowledge that the application was received, to provide the file number, to tell of the approximate time that it will take to process that case, based upon the category, based upon the country, and any other information that we think that the applicant should have right up front, whether that's how long it takes to process a medical or how long it takes to get a police certificate if you're a national of a certain country. So this is an acknowledgement of receipt letter, and all applications lodged after November 1st abroad will have an acknowledgement of receipt letter sent out within 4 weeks of receipt of the application. Okay? Now, we will send that acknowledgement of receipt letter either to the applicant or to his counsel, depending upon which he decided was the person that we should respond to. So in that way, we're sending out only one letter, not two, but there's a provision in the IMM8 for people to identify where they want their correspondence to go. Now, in terms of representations, we find that just that one letter alone cuts down on representations. Because in fact, all clients really want to know is how long is it going to take? What's my file number, and what do I have to do next? How long will it be before you hear from me again? So this will cut down on the representations that you make and that we have to answer quite significantly. However, if you don't have if you don't get that acknowledgement of receipt letter within, say, 8 weeks, and we say 8 weeks because not every place is the first world. And speaking on behalf of, for example, the Damascus office, where we have applicants from Iran, and the only way that we can communicate with them is in Farsi via the diplomatic bag through Ottawa, it can often take 8 weeks to send an acknowledgement of receipt letter. Not for it to get out of the office, but for it to be received by the applicant. So if you have a case where you haven't received an acknowledgement of receipt letter from the visa office within 8 weeks, or processing isn't completed in the time frame that we told you, or there's a material change of circumstance, if there's something that you feel that the visa officer should know when considering the application, then you should make a representation to the visa office. And we guarantee, to the extent that we can, that we'll respond within 30 days to that representation. If you're going to do it by fax, we will answer by fax. We're not going to do it by fax, and you send your request in by fax and we answer by letter. That's a game that we don't play. At the same time, however, while you're waiting for your answer from the visa office, we would be grateful if you didn't go to the ambassador while you were waiting. Thank you. Or to your MP. We will get to you. It's often just a question of time, volume, and means of communication. We have certain adherence mechanisms. The bottom line is that if you don't get a response from the visa officer who's processing the case, you can then go to the program manager. And that manager, for example, if you send a fax, will respond within 10 days back to you by fax. Now, if, for example, and it's entirely possible, that you have a program manager who doesn't respond within the 10 days, and you have a series of cases where the program manager is not responding at all, then you can go directly back to the international region headquarters, to the geographic division responsible. And in the reorganization of headquarters, we still have the same geographic divisions. So you still have Africa, Middle East, still have Europe, still have Western Hemisphere, and still have Asia Pacific. So you go back and say, look, these people aren't answering my inquiry, or this is a series of cases where service has been less than set out in the standards, and we will get on that. And we commit from headquarters to respond within 10 days. Okay? You know, at the same time, we ask for your forbearance. We do try and do it to process a case within established timeframes. And what we do is we have a tracking system in headquarters. So posts will go back to headquarters data to advise the client the amount of time it takes to process the application. In many instances, the processing time at a post is in fact faster than what headquarters thinks. So you may find services faster than what is committed to in the letter, but let's leave that as a happy surprise for practitioners. Okay? Now, if you make a representation, and it's not on a material fact, it's just because your client is pressing you and he really just wants to know what's going on. If it's within established timeframes, we won't answer. And you have to understand that we receive so many representations, we won't answer that. Okay? If you keep making representations, then we'll certainly stop answering you. And that is also in the agreement. And if you keep doing that, then we will also go back to our headquarters. I don't know that anything will happen then, but at least we all feel good about having dealt with the problem. Does anybody have any questions about that?
I have a question.
Go ahead.
All this must be subject to the new one-step or perfected application processing, which may or may not come, but it's said to be coming in now in certain posts and certainly all around the world on April the 1st.
Yeah, I can't address that. Maybe Bill can. But what we are moving towards, as you've heard from Cecil, is one-step application or the perfected application. The idea being that it's very expensive to maintain cases and people in processing backlogs. Wouldn't it be great if they all fronted up at the same time with everything done ahead of time and we could give them the decision quickly? That's the notion.
May I retreat to one problem that we now have that will not be addressed by the one-step or perfected application? As you know, some visa officers sometimes make mistakes, and we're faced with the requirement to challenge them. And if you take so much time to answer, we're out of time for the federal court, which has got a 30-day time limit for visa officers, and in the case inland processing, 15 days. How are we going to address that?
And I think once you file for judicial review, we're obliged to proceed.
Well, once you file the judicial review, you can't talk to us at all.
There you go.
And that's a problem. And I don't think the federal court judges understand that either.
No.
Because Justice Department says, well, now you are our client and you've got to talk to us.
Yeah. The judicial review proceeding we find very frustrating abroad because in many cases, because of the time limit, lawyers have to file, but they think that they can resolve it otherwise. But the time limit is such that you feel you must file. At the same time, because you must file, we have to prepare the case as well.
Well, if we don't file, we're not doing our solicitor's duty to present our client's case. And we could be subject to negligence claims of one sort or another, although some lawyers say that immigration is the happiest cliented thing they've ever done because they see only their successful clients, the other ones they never get to see. So there's not too many insurance claims around. Nevertheless, we have that duty to our client. And in the present service standard system, and I must say you're looking at it, but in the year and a half we've been looking at it, there's no answer. Because ideally, what we have to do, especially when we get some of the letters only with a few days left, we've got to go to the court. And I just had that discussion with a visa officer abroad, and there was a letter which was obviously wrong in the face of it. It said that this person was not a self-employed person because his admission would create no employment. So I said to that officer, I said, program officer,
What?
this is
Say that again.
because his admission would create no employment. I said, it's true, I'll show you the letter. So I said to the officer in charge, I said, you've got an obvious error on the face of this document. Your duty as a program officer is to set it aside. And he said, no, my duty, according to headquarters, is to contact the legal department. So, Charles, do you want to comment on that kind of thing? You're lawyers, do you understand?
You always bring up the exceptions anyway.
Don Cameron says I operate in the fringe of...
The refusal letter, of course, is meant to be the final communication of the results of the application. A great deal of time and effort goes into the preparation of the refusal letter, not only by the officer himself or herself, but in conjunction with perhaps an internal review with the section head or the program manager. I realize that there may be certain exceptions like you're talking about, but as I say, the refusal letter, which takes a great deal of time to prepare, is meant to be final. If we start reopening refusal letters each time somebody comes and questions us, that just prolongs the whole process. And in fact, as we've been advised, a response by an officer other than the officer who made the final decision, then the case could be appealed on the basis of somebody who was not involved in the process making the final decision. In other words, you make your appeal to the program manager. The program manager responds. Not only does it extend the time for your ability to file for an appeal, but it also gets involved as who is actually making the final decision.
Well, Charles, the he who hears must decide rule was specifically abrogated by Justice Strayer in the Chen case in the trial division. He said it doesn't matter. So that's not the issue. I guess what the issue is that if the visa officer to whom you're complaining decides to recognize anything of validity in what you're complaining about, then the time for judicial review begins to run from his next letter.
Correct.
If he does not recognize anything that you're saying, then the court has held that this is just merely a courtesy letter, and therefore the time runs from when it was first sent. This is creating a large problem for us because I'm sure that many people don't agree with the visa officer. Those disagreements fall into two categories. There are decisions which seem to fall within his discretion and which you may not like, and there are decisions which don't fall within his discretion or seem to fall within his discretion but really don't. And it's those latter ones in which I always have to go to the Department of Justice and issue a mandamus. And I don't like it because it's not only time-consuming and expensive, but it doesn't have to be. And you people who are trying to move in the direction of economy should try to figure out some kind of way in which we can have some kind of negotiation, because you're going to have it one way or another, some kind of negotiation of this visa officer's decision, no matter how carefully it was taken, in order to satisfy the client. This, and I've heard more and more from various counsel around the room, that they feel that the only way of being able to comply or being able to cope with or being able to communicate is through the mandamus route. And I must say that in passing, that a majority, not a minority, a majority of these applications for mandamus are consented to somewhere along the road. So I ask you to consider that and take that back home. Do you have any comment, Doreen?
Yeah,
or Charles,
I'm
about
just
that?
curious, if that's the case, is it particular posts, or is it that you're, or is it really a global phenomenon and it's a global problem?
Well, I would think it's a global phenomenon, but you may take it that the posts that are attracting the most heat are those that do the most cases. It's logistically follows, you know.
I also think there's a balance here, too, that we have to be aware of, and I agree that this is something that should be considered. But the balance, as you describe it, are the representations and the number of times that a representative will come back on a case, as you described in the first scenario, rather than the second scenario, and that is questioning the merits of the decision, not whether or not it's within the discretion of the visa officer to make the decision, but on the merits of the case per se. And it's those that tend to clog up the system, and I believe it was those where this policy was put into effect for.
Well, I would think for those officers at those kind of heavy-duty posts that you might implement some kind of policy to review cases of the latter kind, where there is a legal issue or a legal point involved, and where, or additionally, where the letter is so obviously wrong on the face of it, and those kinds of decisions could be made quickly without too much trouble, and that they be done, let's say, within an immediate period of 15 days of receipt of a fax to that effect. And therefore, I think you would dispose of a lot of those kinds of difficult problems, and you would know within the 30-day time period. The other thing that I would suggest, with the greatest respect that you take back to your mentors, is that the Immigration Act should be therefore amended and revised, or the Federal Court Act, whichever of these two imposes the time limit, to enlarge the time limit from 30 days or from some other start of a negotiated letter or some other thing like that. And we should be looking at that immediately, because with so many cases going on in so many places, then this is urgent.
No, point well taken.
Now, while we're talking about service standards, I keep on hearing from a counsel who call me about that old chestnut. Do you have a lawyer? Why do you have a lawyer? And how much is he charging you? And when I raise this with some visa posts, they say, yes, we have to know these questions because of the prevalence of fraud. I say, amongst lawyers? They say, well, amongst everybody. So, do either one of you want to answer that question?
Charles.
Thanks, Doreen. I would hope that visa officers are not inquiring of lawyers or consultants or any other representative as to how much it is costing for the services. That's none of our business. I appeared before the Standing Committee on Immigration just a few weeks ago, and this topic was the topic of the day, lawyers and consultants. And we tried...
They were standing, were they?
Pardon me?
They were standing, of course.
They weren't standing and applauding, I'll tell you that much. But one of the things that was very clear is that this is a private matter between the applicant and his or her chosen representative. This is none of our business. So I don't know whether that's happening routinely or not, and whether or not that question is being asked officially or not. It shouldn't be.
Can you somehow or other carve that in some kind of piece of stone that people can read from time to time?
I think that should be part of the training process of visa officers as well, that this is none of their business.
All right, let's go to a topic that is much on the forefront of my head, and that is Muliadi. Now, I'm happy to tell everybody, and I'm sure you know, that there's an operations memorandum running around that says that before you refuse somebody medically, you have to advise him or her that he's going to probably be refused based on the evidence that they have, and does he have anything else to offer. That letter will specify what it is they think they has, and that it will either be a danger or it will make an excessive demand. I raised a new kind of question that came out of a case called the Schmaley, and that is the medical file and the immigration file are no longer separate identities. They must be together. And if that's the case, should the whole medical file, as it were, be sent to an applicant, or should it be made clear to the doctors examining that they provide copies of what it is they send to Immigration Medical Department to the applicant since he's paying for them? What do you think of those two ideas? Again, I'll let either of you choose. Hot questions.
We did discuss this briefly at the break because we had not been aware of Cecil's questions beforehand. He does this occasionally. He springs certain questions on us. And I do think it merits some further study. There's no question that at the later stages of processing, when we're into the federal court, the complete medical file is available, and it does go to the court. It is in the court record. The refusal letter hopefully sets out all the information on the MS 1017. Admittedly, it may not include certain specialists' reports that may have developed as a result of a furtherance, but the conclusion of the medical practitioner, concurred in by another one, of course, is fully detailed on the MS 1017, which is the letter from the doctors to the visa officer, and should be repeated verbatim in the refusal letter.
Do you think that kind of fairness is appropriate to a visa applicant who is about to be refused?
I don't know if there's also some question, particularly in some countries, of the doctor's opinion going, the original doctor's opinion going directly to the applicant.
No, what I'm talking about is the visa decision, not to the medical decision. If a visa officer says to his client, I'm going to consider this, instead of saying right out in front of the client, I'm going to refuse you because, he says, I'm going to consider this case. And he goes back, and about 21 days later, the applicant gets a refusal letter. Do you think he should be given the opportunity to respond in some way?
He is, as far as I know. The letter goes out and says, we've looked at your case. It appears that you're going to be refused on medical grounds
No,
I'm
talking about the visa decision, Charles.
The visa decision. Well,
not the medical decision.
At some point in the process, particularly where there's an interview, at the conclusion of the interview, the visa officer should be saying, I have considered all these matters. In my opinion, you do not meet the requirements of the Act and regulations because what do you have to say in rebuttal of that? The applicant is given a chance. Procedural fairness requires us to give the applicant a chance at the conclusion of the interview.
Well, regrettably, I have to tell you that that's not happening.
Exceptions again, Cecil.
Well, what happens if there's more than one exception?
Still exceptions. No, I understand that there could be...
Doreen, what do you have to say about that?
Somebody earlier, sorry, 1 second, said that visa officers make mistakes, and we do. And lawyers make mistakes too, and everybody does. And I understand that there will be some of these questions, and I think we have to work to making sure that everybody is well trained so that the mistakes are fewer.
But what are you going to do about before you train these people, and I'm talking about the now, and visa officers say, well, I have to think about this, I'll have to consider it, or I'll maybe even say I'll have to get some additional information, and then refuse.
Yeah.
Well, again, the additional, everything should be well stated at the conclusion of the interview. I have to get additional information. The information I want is the following. If this information states this, then I will accept your application. If the information does not state this, then I have no other evidence to prove this, that, or the other thing, and I will refuse your application.
Yeah,
there should be a clear direction by the visa officer at the conclusion of the interview exactly what he or she is looking at.
You and I couldn't agree more, but I tell you, it's not happening. And for one reason or another, or because the visa officer has to go to lunch or has some other appointment, or has too many cases on that day, or just has to consult with somebody else like the manager or whoever else, it's not happening. And if that's the case, let's make it hypothetically it's not happening, should there be some kind of miliati fairness going out?
Well, I completely agree. In fact, I'm surprised that it's to that extent because I've worked in a number of very big visa offices, and the procedure is that when an applicant is interviewed, as Charles says, you tell them the outcome of the interview at the interview. They shouldn't be leaving the office thinking, one, that they don't know. They have to know the answer.
Well, I agree too, but what happens when they're not? I mean, for example, I have one case that came into my office on Friday when I was not there, where the person said, the visa officer said, I want you to get this additional information on the very same day. The visa officer sent a refusal letter. I tell you, it's not happening.
Well,
And if it's
not happening?
It's not happening, and the typical thing is if there's one refusal, it says we'll be in touch with you in writing. And you know that's a flag for saying it's going to be a refusal. Now, if they're going to be accepted, they always say something like, well, this looks like a good case and subject to medicals and security, and I think it'll be approved.
Yeah,
if it's going to be a refusal, it's constantly, we'll be in touch with you in writing.
Yeah, I don't think that that's fair. How about if we do something that's like Service Standards on Representations Part 3, and something to deal with, you must tell the people at interview, because that's quite clearly out there, in some offices, but if it's not happening, then we should know. I think that's the responsibility.
The embarrassment of having to say to somebody, look, you don't make it and you're going to be refused, and this is why.
Yeah, but we should be training that out of people.
JOs, mostly JOs, junior officers,
Yes.
as opposed to more senior people.
Yeah.
There is an element of that. There's also an element of having people not being able to accept the decision right at that point, particularly if it's negative. But there should be no reason why.
Does that mean, Charles, if you say you're going to tell me no, I'll have a heart attack?
No, but some people do
gets
tend
nasty,
to
yeah.
do
It
tend
can
to
be.
linger in an office and will not accept it, and you get into sparring matches, and you say, but I told you so, and but why can't you, and things don't proceed along an orderly path. But there's no reason why, again, a visa officer cannot say, I am not happy with things the way they are. I do not see that you have met the obligations of the Act. If things don't change, your application will be refused. However, I would still like to think about it. There is that, again, a clear direction, although a decision does not necessarily have to be reached at that very moment.
But I think your point is quite right, that it is, if it is out there and that's what's happening, then it seems to be a problem, perhaps in training, perhaps in procedures. In our big visa missions abroad, for example, Manila or Hong Kong or New Delhi, the number 2, not the head of the office, but the number 2, is usually responsible both for liaison with the lawyers and consultants, but also with quality control and training junior officers to ensure that there's some standardization and everybody's just not off doing whatever they want, that we are treating cases fairly. And this is something that we can also do in an instruction to make sure that the number 2 in the big visa offices make sure that people are told before they leave.
I think there's another problem too. For example, one of the things that happens in North America is that the program managers will invite people like Cecil or me or others to come in to talk on specific topics like criminal and disability. I've been doing, Cecil does them on medical issues, and the staff gets a very good grounding. It's very hard to do that overseas on those kinds of things, and maybe the bar and the commission, Fiscal Commission Department, should be working on something like that when some of us are overseas, possibly to work out some of these kinds of programs for junior officers. They are helpful.
Yeah, no, I think you're quite right.
Can we move on for a second, because there's 2 points that I want to talk about before we close and throw it open to questions. One is this business that has started since Gao, and if any of you read the Immigration Law Reporter, or if you heard me before, I'm continually talking about it. That is the role of the visa officer in medical decision making. He has a role. It's not been well developed in writing, so far as I can see. Various judges have spoken of it, depending upon the kind of case that it occurs. It mostly occurs in mentally challenged cases where you have social services as opposed to medical issues that are part of the decision. And I see the role of a visa officer as looking at the material to determine whether or not the medical decision has validity, in the sense that there's evidence to support it. And I also look at the role of a visa officer as being the fact finder, or you might say the person to whom facts are submitted, and he in turn will examine the applicants, look at the facts, and pass his impressions on to the medical people. I also look at the visa officer as a person who should and ought to weigh evidence when it determines reasonability. I've been shot down on the last 2 items, and apparently they agree with me on the first item. Do you have, I know I'm springing this comment on you, but do you, this notion on you, do you have any comments or ideas? You're very experienced people, and I think you understand where I'm coming from, particularly in those cases which relate to social services.
I think this is one of the things we discussed at the break. We said we were going to take back and find out.
Yeah.
I agree that the visa officer should ensure that the whole process is going according to the Act and regulations. We do have to acknowledge that we're dealing, particularly in mentally challenged cases, as you brought up the example, with very, very sophisticated and complicated medical evidence. As you know, medical experts in cases may not agree. So what we have is two medical doctors having to agree on a topic that I'm sure most visa officers would not feel competent in discussing. But nonetheless, there is an obligation to ensure that all the evidence is there for the medical people to consider, and that the process is done fairly.
Well, I'm sorry.
Yeah, I think the bottom line, practically speaking, is that it's not the doctors who decide whether a family migrates to Canada or not, it's the visa officer. So that the visa officer takes the medical information under advisement and takes the recommendation of the physicians that the family falls or the family member falls under 19(1)(a)(1) or 2. And often, and you probably will recall that there was a long while where doctors actually mixed up 1(a)(1) and 2. And so we had a whole host of cases that were being processed, refused under the wrong criteria. Visa officers have to ensure that the grounds for which the family is being refused are justified, are well thought out, are consistent with the law as we understand it. I think that's fair.
You know, and if visa officers have to do that, is there something to tell visa officers how to make that determination whether the refusal is reasonable at law when we cannot make up our minds whether excessive demand means cost or delay of services, or both, or one or the other? That's one thing I want you to take back, because it comes out of the recent case of Ishmaeli, decision of Cullen, and it seems very, very difficult as I read the decisions, the medical decisions. The Supreme Court judges or federal court judges themselves don't really understand what are the criteria that are behind excessive demand. So how can a visa officer make up his mind as to whether or not the medical officers are reasonable? And they don't tell you either, other than the odd time they mention costs, which may or not be a criterion. So I really think that you have to do some soul searching there. The other point that I wanted to make before we throw up, before we throw a little Freudian slip, before we
go back a long way.
Before we throw the matter for questioning, is the issue of the CCPEE, or whatever you want to call it. And last Monday, when I was up in Ottawa, I found out that anybody, there's a OM around saying that everybody who claims to be an engineer must send $175 to this organization, even if they're a Canadian engineer, North American engineer, or they're working as engineers or professional engineers or have a professional stamp. And at that meeting, I under questioning, I never did understand from the officer why that had to be. And perhaps you can tell me how you feel about that as a selection criteria, particularly where the person coming here, as Howard pointed out in that meeting, wasn't depending upon his engineering professionalism at all as part of his job.
Yeah, I must have left the meeting early.
You did at that time, I think.
Yeah.
No, but this whole because this is now implemented as a decision that you must go through the CCPOE. You don't even go through the visa office. You send it to them directly, and unless the visa office has a certification from this organization that you're an engineer, then they will refuse your application as unqualified.
And what would you rather see?
Well, I'd rather see that if I were claiming to be a professional engineer, I'd rather see it. Sure, I don't mind that. But if the professional engineer is not part of what I intend to do in Canada, why do I do it? And secondly, why should I, as a Canadian engineer, a person who's licensed in Canada, or indeed in North America, have to go through that process? Yeah,
I don't know about the latter at all, although common sense would say that if you were a Canadian engineer and trained in Canada and already accepted, why would you have to do that twice, obviously?
Yeah. Well,
I think your other point about if he doesn't intend to work as an engineer, he's not applying to be an engineer, why would we make him? Well, we wouldn't.
Well, you do. You do. That's the problem. And if you don't know,
I don't know why.
If you have an engineering degree, you have to go to the CCP.
Yeah, but what if your intended occupation is something,
No, you have to go to the CCP.
but, yeah.
I believe that is currently under negotiation with CCTT, the Canadian Council of Technicians and Technologists. I was just with Charles Brimley of this organization in Kiev and Moscow, and the idea of having the engineering profession determine whether somebody is a technologist or technician is under review, so that these things in the future can go directly to the CCTT.
well, the second part of that, Charles, is that, for example, in Yugoslavia, they get many, many engineers from process through Belgrade, and Brian Casey never bothered with that because he knew that Yugoslav engineers were very acceptable. He knew from experience that people with this kind of background were acceptable. So why do that if you know?
That makes me nuts because, if we're trying to have global standards so that if you know that you are, as a lawyer, if you submit through Belgrade, the guy's not going to check through the engineering office, but if you submit through Hong Kong, he will. That's exactly what we don't want to see happening. It should be globally consistent, in my view. We either all have experience in evaluating or we don't.
Yeah.
I was with
remember
Bill
you.
Shepherd. Hi, Doreen.
Hi.
I was with Bill Shepherd 2 weeks ago in Hong Kong. And let me tell you what the Hong Kong office does. You put down your intended occupation as engineer.
Right.
You don't have to do the CCPE evaluation. If you put professional engineer, he would be stupid enough to say that. If you put professional engineer, then he makes you go through the CCPE. So he recognizes, as Belgrade does, obviously, that it's a meaningless exercise.
Uh-huh.
If you're going to be a professional engineer, you have to be licensed, so you have to have the professional licensing authority approve it. You just put down engineer,
Right.
which means you do not need to be licensed professionally. You don't have to go through it. So there you have the Hong Kong office and the Belgrade office obviously doing one thing.
Right.
And all other offices, for example, Beijing and everyone else, you say engineer in Beijing, you're going through the CCPE right away.
Right.
Howard wants to say something about it since we're on a question period without having got that way.
I'm just going to come to the microphone because I want to talk to you, Charles. Charles?
Yes, sir.
I'm sorry. I find your comments kind of chilling. Your earlier comments about the finality of a visa officer's decision and the sanctity of it, especially in light of what Elizabeth's selection system, well, I shouldn't do that, the system explained by Elizabeth is going to do. Look, on February the 10th, I'm going to file applications with Murray that have all sorts of things about adaptability, which is like almost like kind of pulling this out of here. And some case analyst somewhere is going to be making some sort of preliminary decision based on that in the dark corridors of the 31st floor of Buffalo, in which there is no effective administrative system in place that permits us to qualitatively determine if the application was properly reviewed against criteria and the objectives of the legislation, as explained by Elizabeth this morning. I would think that you would say the exact opposite coming to the microphone. I think you would want to bend over backwards to make sure administratively that the decisions were consistent across the board throughout the world. I would think that you'd want to keep me out of federal court, cross-examining your officers to death and what they perceive resilience to mean. I would think that what you'd want to do is you'd want to have a huddle with Murray and figure out some sort of a safety valve so that people aren't running off to court using up the federal court budget on discretionary decisions that may be in or out of line with what the legislation holds.
Howard, can I add something to that? Because the answer is in part in this, that where you had 4 items of personal suitability, and there was only those 4 to which the visa officer could relate initiative, motivational, whatever they were, it became easy to see where the visa officer discretion lay, so that if he considered something else about Canada or something else, then he was outside of his discretion. Now with the word adaptability, where are the 4 corners of his discretion? They could be anything. So in fact, when you talk about sanctity of this decision, it's sanctity of anything and will not be able to attack it, whether it's ridiculous, stupid, or otherwise.
I'm not saying sanctity in the holier than thou attitude. Let me make one point.
What do you mean by sanctity?
First of all, let me clarify that Murray Oppertshauser is not the only visa officer in the world. I would like to say that. I was sitting up there beside Murray, and there are other visa officers in the world, and there are other visa offices. So I just want to establish that.
The guy claiming to be Murray Hawkins. So if that's the case, I'm Cecil Rotenberg, and I'm fighting you all on my boat next time.
He has a boat, Murray?
As I mentioned earlier, in dealing with the preparation of the refusal letter, I'm here because I do have some experience, and I want to relate some of the experience that I have, particularly in my last posting, which was Hong Kong, and in the business immigration section. And there was a great deal of time and effort that went into the preparation of a letter. Every single refusal letter was referred to me as the head of the section and was vetted through me. What you see as the final product that goes out may have borne little resemblance to that which started. And a lot of the internal administrative reviews and details will hopefully cure some of the problems that Howard has raised. I understand that it may not be perfect in all places, but there is a very strong element of review along the way, and of ensuring that all the aspects that go into the preparation of a refusal letter say what they should, are procedurally correct and fair, and provide the applicant and anybody else who looks at the refusal letter with all the information that's needed on which to review a case.
Gee, there goes my federal court practice, Charles. That's what we could do.
I'm sure that won't stop it.
Thank you very much. It's our intention to allow for about 15 or 20 minutes of questions, and let me make a program note if I may. You'll notice that the next session that in your calendar is scheduled to start at 12 o'clock, labeled Immigration Update, is quite diverse. It covers different matters. We'd like to try and start that about 10 minutes early at about 11:50, and I'll first be calling up Ben Trister together with Mr. Van Stulden and Murray Oppertshauser to talk about the perfected packaging and some of these new initiatives. And then through the course of the same program, Joey Young will give us a minute or two update on where we stand with business immigration, and David Bruner and Paul Delaney will be joining us toward the in the latter part of that program, taking us up to the lunch break. For those of you who are signed up for the afternoon, let me continue with the program notes to say that they're expecting a terrible snowstorm in Ottawa. Some of our guests who have come to join us at the Huddle with the Experts are going to be leaving a little earlier than anticipated in order to get their flights back. It's rather important to us that we start really promptly. If you could be at your workshops by 2 o'clock at the very latest, we'll get started. Will reduce the breakdown substantially, and your second workshops, therefore, may be foreshortened somewhat by the departure of some of our guests to the airport, but everybody will still get good value. Thank you very much. So, questions now. Far corner.
Yes, sir.
On the issue of the length of time spent to prepare a refusal letter, I would suggest the amount of time that's gone on before an interview, and it would seem maybe appropriate that some of those concerns were raised in the scheduling letter of the interview, where you could prepare the person asked to attend the interview. I've looked over your file, and basically it's okay, but we've got some real concerns in these areas. Maybe you'd like to bring some evidence on those areas when you attend, as opposed to please come to the interview and see what happens. Just recently I had someone go to an interview, and there was all sorts of questions raised that when I wrote back and said, well, if you looked at the stuff that we sent originally, it's all there, and the response was, gee, you're right.
So for the tape, I believe the question is it possible to do a more specific and detailed letter pre-interview when you screen files to obviate the necessity for excessive deficiencies being pointed out after interview and for long refusal letters?
Yeah. There's a bunch of different ways that we could answer that, actually. You know, one is that there's no excuse for the visa officer not reading the file and everything that you've submitted ahead of time. Bottom line, if you've submitted it, and it's part of the application, it should be there. The officer should have read it and should consider it. So that's one answer. The second thing is that interviews are funny things because your clients don't always behave the way you expect them to. So the visa officer goes, well, maybe yes, maybe no, maybe yes, and then he says something dumb, and then he goes back this way. And because we're dealing with humans, you can't predict the outcome, and you can't predict the outcome of an interview. You think you can, but you often can't. So that's the second thing. The third thing is if we move towards the perfected application, maybe some of those problems will not be so evident because the person would come with everything up front, and it's all dealt with right up front. So at the time of making the decision, there's no going away and thinking about it. It's right then and there. I don't know, maybe.
No, I appreciate that, and that, I think, makes it even more important that if you're going to schedule an interview after that process, that if everybody goes to the table figuring that this is the perfected file and that's, that's complete, and you're then going to call an interview, then obviously there is something outside of that, and I think it's your obligation to identify what is outside of that.
I agree with you, and the perfected application is something that we haven't actually even started yet, so who knows. But for example, when you talk about adaptability, what if the person's points that he would receive on the application would be assisted in terms of assessment of adaptability by attending an interview? I think that visa officers in that instance should say, well, I see this, but if I had the guy in front of me, I'd have a better chance of assessing his adaptability. There's provision for doing that, and I think we have to apply it in that spirit.
In an open
Yeah.
spirit as opposed to...
Yeah, absolutely. You see, we're looking for skilled workers. It's not like we're trying to turn them away. We're actually looking for them. That might seem like a perverse way to do it in your view, but we are looking. We do want skilled workers in Canada. And
There's
so the
Mr.
approach has to be
Guji,
positive.
and then there's a lady in a green sweater in the back, and then Mr. Rakai.
Doreen, my question is to raise some user of urgency with the
Hi.
idea of some kind of post-refusal review, representation and review at the visa post itself. In a recent decision at the federal court, Justice Rothstein said that in a case where someone had waited, made a request for a review and was out of time, 30-day time limit, Justice Rothstein said that you should have both gone to court and asked for an administrative review in order to protect yourself from a negligence type of scenario.
In other words, a parallel process.
Yes, but you can imagine how difficult it's going to be for all of us if every time a case analyst says no to a case, we have to protect our client's interest by filing an application in the federal court.
For the tape, the question was, is there provision or can we make provision for an in-house review without starting the clock on our federal court time limits?
Iqbal, it's very clear that Mr. Justice Rothstein contemplated duality of procedure, which can't exist, because if you start talking to immigration people after you filed your notice, then the Justice Department are going to get after you. They'll even threaten you with communicating with their client without their permission, and they want to go to the Law Society. They did to me.
I'm not an expert in that. I'm not a lawyer. But it's obviously something, because so many people have raised it just in this morning alone. It's clearly an issue. Can we take that back under advisement and see if there's something that we could devise or think about at least that would address that?
Can I just bring you a little bit more up to date? Because a year ago, they were talking about this with the Canadian Bar Association, but they said that they couldn't get the review unless we abandon our rights to appeal. They would give us a review then, which I thought was a little bit self-defeating.
There was a question in the second row from the back.
I've recently told my visa officer that if I wish to speak to her about a file, I have to pay an extra $40.
Is that true?
Excuse me, I'd have to hear it before I can repeat it for the tape. You were recently told by a visa officer that to speak about a file you have to pay an extra $40 and obtain a PIN number. Right. And that representations, according to the agreement that you say we negotiated, is only written representations. Wow.
Is this in a visa office abroad? That was in a visa office abroad?
A Canadian visa office abroad?
Yeah, and you're sure it was the embassy? You're sure it was the embassy and you're sure it was a Canadian, eh? how did they charge you? I'm just curious.
Cash check fees.
And did you get a receipt?
I didn't pay. I thought it was outrageous. It hadn't happened in any other people.
For the tape, this is outrageous. I think the response from the bench is thank you for bringing this to our attention
Thank you.
because it doesn't sound like it's intended. Cairo.
Would you write that out and give it to me afterwards? Thanks.
Thank you. I think Mr. Rakai had a question.
Yeah, I've gathered so far, I think many of us have, to this point, that we are going to have to become, or gain some expertise in labor market needs in Canada in order to respond to the issue of adaptability. To what extent are visa officers going to upgrade their knowledge? I mean, these are people who are normally outside of the country for most of their working lives. To what extent are they going to be in a position to speak to labor market needs, to know whether a particular professional would fit in somewhere in the country in some industry?
The question being, to what extent are visa officers going to be assisted in making an intelligent assessment of labor market conditions, given the fact that they're not here to read the Globe?
There's certain emotive words that are being used here. Don't forget the new adaptability criteria. It's not what you're looking at are qualities that the applicant has displayed, which would lead you to the reasonable conclusion that they have a certain amount of adaptability. Because the whole idea of adaptability is that we should be moving towards assessing that to the extent that we can on the paper that the applicant has provided. In other words, has this guy moved around? Does he work for an international company? Does he speak English or French, etc.? So your question about should visa officers be trained or upgrade their skills in the labor market is sort of a side issue, but I could be wrong, and maybe Elizabeth can help answer that. Is there something you'd like to add? Fine, she doesn't want to. No.
Okay, I had Ms. Cohn and then you, sir.
You referred to a service line, and also a place that we can contact if the service that we're expecting is not timely.
Right.
What is the phone number and address of each of those? That's my first question.
Okay.
The second one is, in the newspaper I read that in the next year, there's going to be a complete assessment of equivalency of occupations, so that the issue of how a visa office in a particular area is looking at engineers is not going to anymore be an issue.
Right.
Can you tell me?
I don't have the phone numbers with me, but if you wait, I can get them, and then we could announce them. So that's the first thing. And yeah, that's okay, no problem. On the other issue, I don't really know.
Again, the whole issue of equivalency, particularly with respect to engineers and technologists, is under review. This gentleman who I mentioned, Charles Brimley, was, I believe, is now in London. He's been to Kiev, Moscow, and Warsaw, and he's going to these places, meeting with institutes, academies, universities, to attempt to establish some equivalencies in this very technical field.
Only for engineers, or can we expect it to be across the occupation?
Elizabeth?
Can I just ask what your source is for this piece of information? Because it's not me.
One of the Toronto daily newspapers.
Well, I would be cautious about reading into what's in the press, because there's no intention to do a specific assessment of equivalency of occupations at this time. There is a working group that's looking at accreditation, a federal provincial group in credential recognition, and is trying to address the whole issue of equivalency and recognition, which is a complicated federal provincial issue, as we all know. But we have not, in the new selection criteria, put anything out that says that there will be an assessment of equivalency of occupation.
So in response to a question from the floor, we have learned that there is no specific federal project at this time which is going to bring us an imminent educational equivalency. Giddy Mammon, the last question of this session before we ask Mr. Oppertshauser, Mr. Van Staaduinen, and Mr. Trister to join us. Thank you.
I'm wondering if I'm the only one who's run into this problem lately, but in the last maybe 2 months, two of our clients at 2 different visa posts missed their appointments for interview because the correspondence we sent to the client when we gave our offices the
mailing address, and they didn't receive the notice of interview until long after they've gone, and we have to reschedule. And it's not a big deal, but is this some sort of have you received other complaints like this, or is it just that I run into some bad luck?
Moscow's like that.
I'll tell you, we wrote to the embassy on that one file at least twice and asked them to please reflect our address as the mailing address, and they declined to continue to receive it, and there continues to be some significant
Is it a
local mailing.
I've had that problem in Moscow.
I think one was in Delhi and one was in Damascus.
Yeah, a third world post, as you can appreciate, unfortunately doesn't work according to first world expectations. And so you're dealing with local staff whose first language may not be English or French at all. These are things that happen, unfortunately.
But can the visa post not be, just reminded that the mailing address is the mailing address? I mean, that's why we provided it.
Well, yeah, sure.
It's not too hard. It's not a
No, we can do that. Sure.
The last response was, again for the tape, to the question of why mailing addresses, if they happen to include barrister and solicitor, don't usually get respected in some third world countries. Well, thank you very, very much, and I do appreciate your assistance participation. And if we could bring up the transition, please.
I'll get them the phone numbers.
Do you want to say a word while they're getting into place? Do you want to say a word while they're getting into place? You were going to talk about it? Okay. While they're taking their seats, we indicated that there have been a lot of questions about business immigration and whither it goes. Joe Young is going to make a small report to you on that subject.
Well, really, there's not too much to really say what's happening in business immigration. As I'm sure you're all aware, business immigrants are the investors, entrepreneurs, and the self-employed. For 1996, the immigration plan's estimating between 18,000 and 20,000 business immigrants. Now, I have doubt that we're actually going to reach that level, but so be it. This year, each category of business immigration has been under review. First, the Immigrant Investor Program. The minister commissioned the Sharwood report to look at the Immigrant Investor Program. Those recommendations came out September 7th. Business Immigration says that the new regulations with regards to the Immigrant Investor Program, a draft of them will be coming out April or May, or March or April, excuse me, of this year. The moratorium that's been in place on the immigrant investor funds will continue. There has been no anticipated extension of the moratorium past the July 1st. So they think that the new regs are going to be in place by the July 1st deadline. Now, the same thing with the entrepreneurs. That program will be looked at with regards to the same regulations. We'll look at the entrepreneurs as well. So March or April of this year, we're going to have some draft regulations for consultations. Now, the self-employed program, that is going to be abolished with the new regulations that are coming in. The self-employed is going to be merged into the independent skilled workers. So basically what I'm saying is self-employed is still alive and well now. If you got some applicants who may not qualify under the rules of the new independent skilled workers, look as a self-employed, because those rules have not changed, nor have the entrepreneurs nor the investors. Those are all still in existence until these new regs come in. That's basically it. Thanks.
Ben?
Just a little aside on that self-employed point. A lot of the occupations for which one might be self-employed appear in the mandatory arranged employment occupations. Kind of an interesting concept. How do you get a job validation for someone who's self-employed? You need a Canadian employer, so I expect they'll be working on that one. But fortunately, they have a few months to do it. So it's my pleasure to be here today to talk about C-44 and also about the new one-step application process. We are going to start just by introducing our panelists, who are, we have David Brunner, the second fellow over there who's chatting it up. I love the fact that in David's biography, he says he articled under Carter Hoppy. It's only fitting that Carter's name be mentioned since he's in Dubai and can't be here personally. It's the first program in a long time Carter hasn't been around, and he's a fun guy to have around. And for that matter, so is David. David's Carter's partner at the law firm of Hoppy Bruner, and David has been on the executive of the CBAO Immigration and Citizenship section for quite a long time. We have to David's right, Paul Delaney, who joined the Federal Public Service in 1972. Following a 5-year posting as head of the adjudication section in Toronto in 1984, he was transferred to the Immigration Policy Branch at National Headquarters. And for the past 6 years, he has held the post of Director, Case Research and Review with the Case Management Branch. His primary areas of responsibilities include the criminal rehabilitation process and the administration of the recently proclaimed Bill C-44, Danger to the Public provision. His talk will be interesting, and he knows everything about your worst clients. Or your best clients, depending on the kind of practice you have. Murray Oppertshauser, at the end, it's Oppertshauser. Joined the Forest Service in 1969. He is not actually the mythical figurehead for visa officers around the world, but he has been around the world. He's had many postings to places I hope never to visit, not including Buffalo, although I only visit there because Murray's there. We're going to talk a little later about some of the initiatives that Murray's brought forward in Buffalo. Since his arrival, he's done lots of interesting things. He's certainly gotten his feet more than wet in Buffalo. I hope you'll touch a bit about on your interview philosophy, how long interviews should take, and things like that, when interviews should be required and when interviews should just be foregone in favor of requests for additional documentation in other forms. Murray's a progressive thinker in the area, so we look forward to hearing from him on that. And we also have Bill van Staaduinen, who has, I think, maybe the longest biography. He started in citizenship and immigration in 1965, has held many posts, and one of the most interesting aspects of what you've done, I think, is probably preparation for the summits. Unfortunately, you won't get to hear about that kind of work today, but well, maybe at lunch. And now, or in August of 1995, Bill returned to citizenship and immigration to manage a wide range of initiatives in the area of selection, a major element of the department's comprehensive renewal agenda. Now, Bill and Murray and I are going to start with this revolutionary discussion on the pilot project. I'm sure you're all aware, we all share the same frustration on behalf of our clients that these visa applications take a long time to process. A lot of the delay is due to the fact that documents arrive at various stages during the process, and they never, and it takes a long time to get them on file and for the visa officer to realize that they're there and the file can be finished and so on. So the system itself is obviously inefficient. The government doesn't have money for inefficiency anymore, so it's rethinking how it processes applications. And these pilot projects are going to be a critical part of the government's planning in how it deals with applications for permanent residence in the future. In theory, the government is certainly striving for standardization around the world. One example of that is the professional assessments and having them done by every applicant, regardless of whether the applicant, say, has a US license and therefore obviously could transfer over to Canada. We're going to make them do everything. We're going to make the applicants do everything. When everything has been done, at that time we'll take a look and we'll get back to you in short order as to whether we say yes or no or whether we want to see you. That's the underlying philosophy of the one-step process. The government's going to make you do more work so that it can do less work. I think it's pretty much that simple. What's interesting, and I hope we'll get into this in the workshops this afternoon, is that on the one hand, you want to paper process as many people as you can. And on the other hand, you've got a selection system which focuses on, to a great extent, language and adaptability. In Seattle, they used to say, I don't want to see a file unless you can slide it under my door. And that's not going to be the case anymore. as far as I can tell. It's going to frustrate people, but the kinds of submissions that Carter can't help himself. He's just, volumes. And Carter's going to do great under the new system because he's going to give them everything and more. And that's what you're going to have to do. So one wonders how we can make both systems work together in Canada's interest. When you understand that standardization is an important part of what the project should accomplish, and one-step processing should accomplish, it may surprise you to know that for various reasons, visa offices involved in the pilot projects can't agree on how to standardize their own projects. So you've got a one-step application in Buffalo, which is very different from the one-step application in London, and the same with Hong Kong. And I haven't seen Manila's kit yet, so I don't know about Manila. So you have to be careful to understand that these systems are all similar but different. Part of that, I think, is because the government wants to test how it works in different areas. Part of it's because the people who are responsible for the pilot projects in different areas don't all agree on who should be doing what and when certain documents should come. So I'm going to just get into a bit of what I see as the inconsistencies of the pilot projects and why you shouldn't just take the kits at face value. So far as I understand it, the courts have said that to complete an application, all you need is the application form and the fee. You get the form and the fee in, you get processed under the point system that's in place at that time. You will see, sorry Marie, you will see in various kits, including Buffalo's latest draft, a statement that says you should not submit your application until you have gathered all the documents requested. Packages submitted with the missing documents, incomplete forms, or improper fees will not be assessed until all the information is received, and that statement is repeated several times throughout the kit. At the National CBA Immigration Section consultations with the government that were recently held in Ottawa, we made it clear that we do not view this processing statement to be accurate. We believe that the government is inducing people to detrimentally rely on the information in the package, because what could very well happen is, since you're required to do all the work up front, which in some cases, like London, includes doing the medicals first, in all cases includes getting the police certificate first, you will find some clients will be in a situation where their application may not make it in before February 8th. We have taken the position that those statements have to come out of these kits. And you must understand as practitioners that you're not bound by the statements in the kits. Throw your paper at them as and when your paper is ready. That's the end of it. Hopefully, in time, this whole issue will be resolved. Perhaps the government may define what an application is so that it's different from the present application, but for now, they're stuck with it. Now, part of what I'm going to say, I'm going to sound unduly negative. We like the pilot project. Anytime you can get visas through the system faster and more efficiently, we're happy to participate. Just like, we had this meeting with Elizabeth, and after the meeting, you'll forgive me, Elizabeth, she said, isn't there anything you like about the selection system? And yes, there's plenty that we like. Obviously, education is better under the new system than the old system. Obviously, discretion is, in terms of how it interplays with the rest of the system, is better under the new system than the old system. There's lots of good stuff that they've done, and like any system that's very complicated, people are going to make mistakes. That doesn't mean that they're not engaged in good work. And the pilot project is, I think most of us who've had an opportunity to review it, is essentially a good concept. The issue is what happens through the various in the various offices. I just want to touch on a few things. In the medical side, there's a new pilot project for medicals locally in the Hamilton, Wentworth, I think, and Buffalo areas, and Toronto areas, where they're changing who you go to. You go to 3 private contractors, and they'll be able to report M1 people who pass their medicals under M1 directly to the visa office. Otherwise, the files are going to go to Ottawa. There are kinks about how that system is going to work, but for now, as I understand it, Buffalo's not requiring medicals at the front end. Neither is Hong Kong, from what I can see from their kit. But in London, you file the medicals, you do the medicals first. You get all your immigration application together, all the supporting documents, you bring those to the doctor. You have your medicals done, and the doctor submits your application to the visa office. When? We don't know. I had a client of mine paid the doctor for a courier, and the doctor pocketed the cash and threw the meds in the mail. So and what happens with lock-in? When do you know, if you don't have control over when your application is submitted? So there are issues there that need to be considered. Presumably, Marie and Bill will have an opportunity to talk about the lock-in issue. In Buffalo's kit, they don't say whether you're locked in or not if you submit an incomplete application. In Hong Kong, they say they're going to return your application with the fee uncashed. In London, they're going to return the application. They're not clear as what happens to the fee, and you're going to get a 90-day lock-in. In Hong Kong, Hong Kong's the only post that has a business supplement to their application package. On police certificates, all of the offices give different instructions. Buffalo's has the best instructions in our view. What's interesting is that if you're applying in London for someone who needs a Hong Kong police certificate, the letter as drafted in the London package to get the police certificate won't be sufficient for Hong Kong because it doesn't have a signature on it and it doesn't put the applicant's name on it and so on. So I understand that my information might be out of date because there was a meeting in Hong Kong between the visa office and the police there, but they're trying to work out these kinks, but you have to be aware those exist too. Processing time. Buffalo's going to get back to you in 45 days with an interview notice, but they're not making any commitment in their kit to the total amount of time required if the interview is waived or if it isn't waived. Hong Kong says only that your application will be complete within 4 months after the medicals and all the other documents have been received. In London, you get your visa in 12 weeks, or you get a refusal or a request for further information or an interview. So you can understand that you have to view each kit differently. Each one is designed to systematize what goes on in each office. They want to see your applications in a certain way, in a certain order. London's even got little strips of paper you have to cut and attach to your supporting documents. So I would just invite you to be careful in how these things go forward. And we'll hear from these two gentlemen about their perception of what the government's trying to do and how it's going to be implemented in Buffalo in particular.
Okay. Thank you, Ben. I'm pleased to hear you say that you like the pilot projects because that's very crucial to what we're trying to do. Let me start, I'll back you up a bit by introducing myself. Ben actually pronounced my name right, and I want to give him credit for that. It's Bill Van Staaduinen. And you can see from my CV that I haven't been at a post abroad for quite a number of years, so that I'm not coming here pretending to be a process expert. What I do have, and one of the reasons that I was asked to take on the responsibility for the project that I'm going to be talking about, is that I'm considered in the department to be a project management expert, and we don't have too many of those. Everybody knows, I guess, that the department is facing a situation where we are going to have major budget reductions along with every other government department. We will be, the department is going to be cut by $54 million effective the 1st of April 1997. That's a 10% roughly cut in our total budget. Up until the 1st of April 1997, we have been spared those reductions because, largely because we were able to introduce something else that you'll all be familiar with, and that is right of landing fees. But the reductions are coming, and we have to be ready. We have had, for the last couple of years, in anticipation of some of these things happening, a process in train called the Business Process Review. We have looked at all aspects of what the department does and how it does it. And the projects that Ben has just been describing, the pilot projects, and what you heard earlier from Doreen and others about the one-step application process, or it was, we initially called it the perfected application process, but that turned out to be a little bit misleading because people somehow got the idea that it was going to be perfect. But all of those projects are now at the stage where the department has brought in a team of people like myself and others, project leaders for specific projects, to implement the changes that came out of that business process review. One of them is this one-step application process that Ben has been describing. I mentioned the budget cuts because the reductions that we will face are not very far off. And in fact, the lead times that we require for this are much less far off than that. We know that many of the changes that we will have to make to the way we do business will have to be in place by next summer, i.e. the summer of 1996, if we are going to realize the kind of savings that the department must realize. And that will apply to the old and the new regs, selection criteria, and we will lose those resources whether we're ready or not. So it affects all of us, not just us in the department, not just our clients, but you as well. And we need your help to make this work. So it's easy to sort of pick holes in the pilots that we're doing. We're doing them differently from one post to another, as you've already heard from Ben. And we're doing that deliberately because we don't want to lose the possibility of good ideas being introduced in certain posts like Buffalo or somewhere else and being missed because we try to impose a system from the center. They are pilots, and they're intended to test the systems over the next, 4 or 5 months, 6 months. Some of them will be going on longer, so that we can take advantage of the improvements in efficiency that are possible. And the department has never been known for efficiency. In fact, probably one of the distinctions that we have, dubious distinctions, is that we're famous for processing delays. We recognize that. And we're finally trying to do something about it. With your cooperation on these pilots, we can make progress, and we're very optimistic that with your cooperation, we can make major reductions in processing times across the board. But we can't do it without you. And we can't do it if we get nitpicked to death on pilot projects. And that's easy to do. In fact, it's a lot easier to do that than it is to sort of roll up our sleeves and get on with the job and make the changes that we all know are necessary. It's not just you do more, as Ben said, so the government can do less. It's, yes, people will have to do more, but there's another way of looking at what we're trying to do, and that is that we're providing you and we're providing your clients with more control of the process than they have ever had before. We're giving an opportunity to provide the documentation, to pull it together, and to come to us with an almost completed application that is almost ready, and hopefully in many cases it will be ready, for an early decision. If we can work together and get this system up and running, using the pilots that we're now involved in over the next few months as our means of testing and improving and building the new system, then we can end up in a situation where not only will clients and you have more control of the process, but we will also save the Canadian taxpayer substantial amounts of money. And we don't have any choice about that. We know that. And that's what we're trying to do with these projects. We know, I've mentioned that we have a short window of opportunity. And Ben has raised some of the concerns that there are about the pilots, and we understand those. We know that we have, we have to provide applicants with information. We're trying to provide them with information that adheres to the principles of fairness. When Cecil was up here earlier, he mentioned the letter that he's written that he didn't get a reply to. He doesn't have a reply because the letter that I sent the middle of last week crossed his. Because the meetings that we had on Monday last week to talk about some of these issues, we addressed the question of the lock-in issue and whether, I don't know, there seemed to be a question about whether it was legal for the department to conduct pilots. Anyway, we've addressed those. I've done a letter back. I guess they crossed in the mail. It went to Howard because that's what we had agreed at the meeting where the letter would go. Hopefully that will help address some of the issues on things like lock-in and what we do with the whole pilot process. I'm happy to address more specific items if as people have questions about that. We are committed to do the following things. And again, you have to recognize that some of the information that you're being given, and notice that there are 3 packages in your kit from the different posts. We are committed to providing applicants with full information ahead of time. If what's in 1 or 2 of those kits doesn't seem to meet the requirements of fairness, in your view, we'd like to hear about it. We've already heard from Cecil. And we will try to adjust the wording accordingly, because we don't want people not to know what their options are when they are asked to participate in these pilots. We are making a commitment that people will not be adversely affected by participating in the pilots. Okay? What that means is that if you feel that there are situations where people are going to be adversely affected, we'd like to know about it. But the flip side of the coin is that many people, even now at the pilot stage, will be positively affected by the pilots if you allow them to happen. If you don't, we're going to keep having problems. If you take your cases away from the posts that are involved in the pilots and you shop around for some other place and pay the fee for the difference, that's fine, you can do that. But if you are going to do that, you have to realize that if there are substantial numbers of cases that are not part of the pilots, and they're going to posts that usually don't get these things and they're not prepared to deal with them, all you're doing is aggravating the problem of delay. And it is time to deal with the delay problem. We're determined to do it, and I say again, we need your help.
Bill, if I can just interject for 1 second. Although I said that you can file an application and a fee and that's all it takes, for what it's worth, at our firm, we want to participate in the pilot projects. We want to make it work. And the extent to which we can file our applications within the pilot project without jeopardizing their rights regarding the selection criteria, we're happy to do it. So don't take my comments or concerns about it as being a negative comment. By all means, file away.
Thanks, Ben.
Okay.
Just one more point, and that is the 90-day grace period that we're giving. During the pilots, we recognize that there are going to be situations where people are going to be confused and they won't quite understand why there is a change in the process, etc. So during the period of the pilot, we are allowing people to refile. And we are date stamping them. We're giving them this 90-day period during which their applications will be locked in. After the 1st of April, that 90-day period will no longer apply. But for the time being, it is there. Again, the information from the posts is a little bit different in this regard, but we're involved in communication with the posts on that, and that 90-day grace period does apply. So thank you very much.
Thank you. Murray?
Yes. Okay. Well, I have the deep suspicion my name is imprinted on all of you today, if nothing else. At this moment, I'm going to talk about the pilot. Later on, I believe I'm going to be invited to talk about the Area Processing Center, which also exists in Buffalo. From my perspective as a program manager in a large post, this pilot has been a very useful exercise because it has forced us to examine carefully and rationalize what we are doing, what we are asking for, what we are asking our clients to do. And it has been systematized in a much better way than, and perhaps it should have happened years ago, than it has in the past. We are expecting the client to do a lot of work out front. Now, it's unfortunate that this pilot is running at the same time that we're expecting regulatory changes, because our instructions are going to have to change when the regulations change. But we don't have an ideal world. I think that in Buffalo, we were probably closer to a one-step application than most places with the APC. And I'll explain the philosophy of the APC later. So when we were asked to be part of the pilot, we said we think we're a fair distance down the road. And then we looked at how we were going to modify what we do. Bill has talked about the 90-day period of grace. We are very committed to that, because as we receive the case with everything that's supposed to be in it and the money, we will have to create a file. Somebody in my office will have to go through that case and determine what is missing. Then we're going to have to advise the client what is missing. Now, conceptually, it was said you would sit down, look at the case, and if something was missing, you'd send the whole load back to the applicant. We don't find that very practical from a Buffalo point of view. We would rather accept the case, create the file, put the thing on a waiting period, and write the client a stopper letter, or what we call a stopper letter, which says, we need the following, please provide it within a certain period of time. If we receive that in that period of time, we would go forward to process. But trying to make our kit as precise as possible so that we can get as much up front as we need. And that's our objective. We ran our kit past the U.S. program managers in a meeting we had last week in Buffalo, and they seemed to like it, and they all took it away saying they would try and use some of it as soon as possible. But very much it's a dialogue. I can't emphasize what Howard has said or what Bill has said. We're working on this. If you look at something in there and say, why do you want that? That's too difficult to obtain. My people have struggled very hard with the police certificate information, and I think they've done fairly well. But another example is they looked at the family tree and said, throw it out. Nobody can fill that form in any intelligible fashion anyway, so let's not have it in there. I went to my case people and said, do you use that information? They said no. So we said, fine, get rid of it, take it out of there. And so by trial and error and by looking at what we're doing in a systematic fashion, it is hoped that we will have a much better application kit to give to clients. I think I'll stop there.
Actually, if you could make your comments on the APC now as well. I know it was for the end, but it seems
Okay.
to...
Buffalo, as some of you are aware, has two parts. One is the APC, or the Area Processing Center, and the other is the Buffalo Consulate. And for the Buffalo Consulate, it's the same as the Detroit Consulate, and it may well be the same as the other consulates. So that we receive all of the initial applications for the Buffalo and Detroit area, or anybody who wants to file with us from anywhere else. The APC's design was to receive cases and clear the clean or easy cases through quickly, so they didn't get piled up in any backlog. And many of the people who we thought would be applying to the APC will have already gone through a fairly significant screen. They may have been educated in Canada or the United States, they may be working in Canada or the United States, but they have been screened in some way for us to be better able to comment on their ability to function in the Canadian labor market, the things that Liz was talking about. If a person has gone to university in Canada or the United States, we can generally assume with confidence they have a good command of the English language, or if they've gone to school in French, the French language. If somebody sends me a case and the person has gone to school in the PRC and says this person should have 9 for English, what can I say? I don't know. So the cases that have gone through the screen should be dealt with quickly, and then we want to process them in an expeditious fashion. This makes the APC attractive to people like yourselves, because if you've got a straightforward case, it should go through. Now, the APC has had some problems. One of them was our own doing. It was designed to handle between 8,000 and 10,000 cases, and we have received 15,000 this year. I am now in the process of shifting resources so that I can deal with those cases more expeditiously. The APC was supposed to process cases quickly, which presumed you would get a medical result in a timely manner. And we all know that the medicals in North America got tied up, and they have now just been completed. We have received enormous piles of medicals in the last 2 or 3 weeks. Now, it's going to take us some time to get the medicals attached and the cases processed. The Buffalo Consulate will not do anything but visitor visa work with reference to their normal workload for the first week in December, as all the resources are shifted into the APC to bring those cases to conclusion. Hopefully they'll come out. Now, in the APC, we have 4 types of cases. The case that can be waived because everything's there that we need and we can accept the application, or the case that can be refused because it's clear that the applicant doesn't meet the criteria. The second or third kind of case is the case where there's more information needed. And here there has been a considerable debate on the model that we should use. Should the APC, the Area Processing Center, seek that additional information and then perhaps be able to waive the interview and go on? Or should they send that case to the Buffalo Consulate or the Detroit Consulate? At that point, should the Buffalo Consulate or the Detroit Consulate say, we have 2 kinds of cases here, the cases that require interview and the cases that may require additional information. Can we obtain that additional information by some other means? If what I need is a custody document for a child, for example, I don't need to call the person in for an interview to tell them that. We can communicate that by letter, we can communicate that by fax, we can communicate that by telephone, and we can communicate it through you people. And then the last group of cases are the cases requiring interview, which then go out of the APC and into the consulates. Now, important in all of this, and it's been talked about some today, but we as the program managers have to use the resources we have more carefully. And by that, I mean obtaining reports through CAPES so that I can look at what each officer is doing, what each case analyst is doing, because I want some consistency in there. If I've got one person who over 2 or 3 or 4 months has a very high refusal rate and another person with a very low refusal rate, or a very high to-interview rate and a very low waiver rate, I want to be able to look at that and then talk to these people and say, let's all get this going together. Let's have some consistency. Now, what you as consultants or lawyers want from an office, I think, tell me if I'm wrong. You want predictability. When you tell your client that you think this case is going to go, you don't want the visa office to throw you a ringer and do something that you didn't anticipate. You want consistency, so that decision-making should be consistent. You want a reasonable processing time and a response within service standards. If we can provide those things, then we will be doing our work in a way that makes your job easier and makes our job easier. There have been some problems in the APC with responses. We're working on that, but very important here, I don't want just straight status requests of cases where there's no reason for a status request. Now, there's a very interesting little phrase in here that I would like to touch on a little bit. The Buffalo 15-day administrative review period. Those aren't my words. I talked to Howard about them. When we had a meeting of immigration lawyers in Buffalo a week or so ago, they said, and we've talked about it here as well, what happens to a case where the decision is right off the wall, where it's out of the authority of the visa officer to do that? Now our only redress, as Cecil has said, is to take you to federal court. Is there another way around that? I said, I don't know, perhaps. And so Howard and I talked about it, and we thought maybe I could institute a review. Now that review takes place anyway because I'm looking at what my officers are doing. I dig up their cases, I look at their refusals, not as regularly as I should and as regularly as I'm going to in the future. But that review takes place. Now, if I look at a case and I see that one of my people has made a mistake, you go to them and say, look, this appears out of line, let's fix it. Now, I said that if you found a case that was really out of line, not just a quibble over the assigning of 4 or 5 points, but somebody has made a mistake, if you wrote me, I would look at it. If I didn't agree with you, I would send you the normal letter, which is, that's very interesting, but this case has been decided and it's gone. If I had a problem, if I saw that there was a problem and I agreed with your contention, then we'd do something about the case. I do not envisage this as a means for keeping your 30-day period open. And if I get more than a few letters from any of you, I'll just throw them away, because that's not what it's for. You've got our decision and it's there. But it is trying to address this concern, and I think everybody in this room has it, of this 30-day waiting period. What do you do when you've got a case that you really think is bad? And no, I can't answer the phone to all of you. We have 380 lawyers and consultants that do business with our office. I can respond, hopefully, to a fax, spell out what your problems are, and if I don't think you're being reasonable, I'll ignore you and send the stopper letter. But that's that 15-day review, and it's not formalized, it's not gone worldwide, it's just something that I tried to say to your executive, let's see if we can do something here, see if it works. If it doesn't work, we're back with what we got, and perhaps then you go to Cecil's desire for a change in the legislation, which would be useful. If we can make it work through cooperation, that's okay. I know many of you deal with my secretary who's going to leave me, who she's going on maternity leave. Her name's Brenda. And she has a great sense for identifying who has a serious problem, or to use her words, who's just sniveling and whining. And, you know, she can pick that up very easily. And the sniveling and whining I don't want to hear. If there's a serious problem, I want to hear about it. Okay?
Murray's been around the block. He knows sniveling and whining when he sees it. And don't send cases to him for review unless they're really off the wall. He can tell the difference. And now we're going to proceed directly to C44 because we have very little time, and I don't want to keep people listening for individual questions, but hopefully our panelists will stay up after to take some of your questions. So now we'll hear from Paul and David.
Then, if you don't mind, just ask Bill one question. What do you anticipate will be the ratio of interviews to waiver of interviews, assuming the pilot project works? Sorry, what do you anticipate will be the ratio of interviews to waiver of interviews, assuming the pilot project works as you hope it will? I'm sure.
I don't think I can give you a specific answer on that at this point. We're hoping that the perfected application process will apply to globally to about 60 to 65% of cases. But a more specific answer than that I can't give you at this point. 6 months down the road, I probably will be able to.
Do you think the ratio will go up? Do you think? Sorry. Do you think the ratio of waivers will go up? Is that what you hope?
We're hoping that will be the case. Yes.
Okay.
The whole one-step application process is predicated on a substantial proportion of waivers.
Thank you.
Could I make a comment on that? Because it's something that's significant that we're starting to look at. A visa officer in this new system, in the APC system, now only gets to see problematic cases. When I was a junior visa officer, you used to get to interview, we interviewed everybody, and you used to meet a nice bunch of folks, and it was very pleasant sometime to have those interviews. You might have asked yourself why you were doing it, but they were pleasant people. It's important now to understand, and it's going to be important for us in the training and motivating of our people, to keep them positive, to keep them not becoming negative, because all they're going to see are the difficult cases.
If you look in the binder for the next panel, the reason why I put this in the binder is from what I call a practitioner's processing strategy. I now address issues related to rehabilitation for my clients as fully as I can in the covering letter. There is a new memorandum, OM, out, which is in your materials, which is not widely known and understood, which is why we have Paul here. And my one point before this panel starts is understand exactly what Paul's saying, because you want that case to remain with Murray, because Murray can make the assessment a lot faster than Ottawa can, and probably have more sensitivity to your particular concerns. So you really want to understand how it is that you get rehabilitation to the program manager level rather than Ottawa level, and this is the reason why I inserted this in the material.
Thanks. You've got the delegation of authority document, tab 13, and it's self-explanatory, but just a couple of highlights. First of all, the authority of the minister to grant rehabilitation in certain circumstances is delegated to specified individuals or persons holding certain positions, and most notably to visa office program managers, certain people at national headquarters, in Canada, to the director of CPC Vegreville, I guess Phil Perry. And these individuals in certain circumstances can grant rehabilitation from criminal conviction outside Canada, or where a person is deemed to have committed an offense outside Canada. It only applies to offenses, indictable offenses, which are equivalent to offenses in Canada of 10 years or less, sorry, less than 10 years. It doesn't apply to the more serious crimes covered by the inadmissible category in Section 19(1)(c). That stuff still has to go to the minister. And if the inadmissibility is tainted in any other way, that is, there are other inadmissible sections involved, then clearly the matter is for the minister, not for a delegate. And there are also other restrictions which are important. First of all, it can't, a weapon cannot have been used related to the conviction or with respect to the commission of the crime. There can't be personal injuries. There can't be serious property damage. And more importantly, the delegate, if the delegate is not comfortable with the delegation, that is, it's a contentious case or something that they feel they don't want to take responsibility for, they can refer that matter to Ottawa for a decision in the normal way. So, Paul, what do you anticipate would be the impact of this delegation in terms of processing times of applications for rehabilitation? They've been taking, as far as I can remember, a couple of years. Is that?
Well, first of all, there was a general consensus, certainly among the bar and certainly inside the department, that the level of authorizing criminal rehabilitation in many, many cases was simply too high, and it was locked into either the minister or the governor and council. And the effect of Bill C-44 was to shift the authority for serious offenses from the governor and council to the minister, with an authority for him to delegate it further. And secondly, for the less serious criminality, 19(2)(a), Bill C-44 gave the minister the authority to delegate it. He didn't have that authority before. And he immediately, 10 days after C-44 came in, he did agree to delegate his authority. Some of that authority has been, as David has just said, has been administratively restricted to national headquarters. But in fact, there's some 70% of the, what we would call lesser serious criminal cases that can now be fully and finally decided by area managers and CIC managers. in Canada. And if that doesn't speed up the whole processing of any immigrant or visitor application, I don't know what will. Because in the past, the criminal process was done consecutively as opposed to concurrently. And in fact, the whole application would sit in limbo while the criminal issues were dealt with, and then it would start up again. So we think that by delegating out up to 70% of the cases that have been flowing through and having to go to the minister's office, you'll see a remarkable difference in the processing time. Those 30% of those 19-2A cases, the ones involving violence or a weapon or more than 2 offenses, that do come to national headquarters, because there are less of them, it's 30% of the cases and 50% of the problems, if you like, because they are a little more complicated. But at national headquarters, I would venture that criminal processing rehabilitation times, which in the worst of times hovered in the 12 to 18 month period, should be, if they are not at this moment, in the 1 to 3 month period. So even the cases coming to national headquarters should be able to be dealt with much quicker. The 19-1C cases, the more serious ones that used to go to the governor and council, you'll appreciate that this is the cabinet subcommittee, and you have to go through PCO, and there's a lot of protocol, and it's a fairly cumbersome system, and they only want to see 20 at a time, and it's difficult to get on the agenda. The fact that the minister has authority to decide those cases now will speed up those cases as well. And finally, accompanying the delegations of final rehab authority, we also increase the authority of the field managers and the CIC managers to issue minister's permits in criminal cases, consistent with the authority they will exercise for final rehab. So for those cases that area managers can issue full rehabilitation, they can also issue minister's permits to allow somebody to come forward for early admission or remain in Canada. A couple of other quick points that I can share with you, because I've been putting cases before the governor and council and before the minister for a number of years, and things that you might want to keep in mind. These are my observations, my reading on the basis of my experience putting these things through. And they're pretty basic things. The minister's apprehensive about criminality. I think that pretty well goes without saying. Little criminality and big criminality, there's a certain apprehension about that. What I've witnessed is an increased number of refusals at the decision maker's level of the exercise of rehabilitation authority. And if not outright refusals, then an extension or a recommendation that, although I'm refusing to grant rehab in this case, I will suggest an extension of minister's permit for 5 years. Don't necessarily remove this guy, but we don't want to see him or his application again for 5 years. I'm seeing more of this coming out of that decision-making process. Some very, very general notes on this. Marriage to a Canadian citizen isn't enough. It's just not enough to bring somebody into the it is enough to get somebody landed in Canada, perhaps, if you're in Canada and everything else is flat. You marry a Canadian, you've got H&C grounds. It's pretty well pro forma. Criminality moves it back across the other side of the line. It's not enough. There's a need for time, passage of time, and a change of circumstance, and a distance from the criminal background and behavior. My experience is that crimes committed outside of Canada are better than crimes committed in Canada. Your client's soiling the nest? That doesn't bode well for them. Nonviolent crimes, pretty obvious here, better than violent crimes. Theft under, better than assault, you got a better shot. One crime, better than two. Having strong business ties, having strong community ties, family ties to Canada is better than having none. Being an immigrant is better than being a visitor. Distance from criminality, let's say 10 years, is better than recent criminality, and 2 different offenses seems to be better than 2 similar offenses. one theft and one DWI seems to go a little better than 2 DWIs.
That's not an adaptability, creativity kind of argument.
And finally, just a couple of quick points that I seem to pick up from these decision makers is DWI is serious. I know that some years ago it was kind of accepted. Today it's just not. I mean, DWI, drive while intoxicated, is seen as a fairly serious situation. Traffic drugs, there's almost a zero tolerance for that kind of thing nowadays. Anything involving a weapon, decision makers are leery about that. Stuff like spousal assault doesn't go over well, and anything sexual. Now, I'm just giving you that. You can factor it in and think about it as you prepare your submissions on behalf of your clients. And finally, if you wish, and I think it was Howard mentioned to me that he would like me to speak for a moment about the danger to the public provisions of Bill C-44, and I'll do that if you wish and if you have a few moments.
Go ahead. Yes, please, we wish, and I want to say while I've got the mic and before you do it, please, folks, if you're not coming back in the afternoon, the evaluation forms are very important to us. That's how we know whether programs are working or not. And also, all the faculty, as soon as you're finished here, please join us at the reception desk right outside for the arrangements that we've made with the faculty. Thank you. Yes, please.
Well, just before you start that, just in terms of the mechanics of making an application, it's very simple. There's a kit. There's a form called IMM 1444, which has always been used. It used to be submitted by the visa officer to the governor and council. It's now submitted, I take it, by the applicant or by his counsel to the program manager or the appropriate delegate. There's a fee. I think the fee is currently $380 for an application for rehabilitation. And there's a kit being developed for clients to make this application.
Bill C-44 also included provisions to, can you hear okay? Also included provisions to permit the minister to issue an opinion that a person was a danger to the public and a permanent resident, a visa holder, refugee claim, or a sponsored dependent. And once he determines that that person is a danger to the public, that person is denied an opportunity to advance his appeal to the Immigration Appeal Board. I think people might be familiar with this situation. It springs from the fact some year and a half, a year ago, that the minister became concerned with the application of the Immigration Appeal Division equity. He asked Parliament for this authority, and they gave it to him, and now he's got nowhere to hide. He's got to use it. The buck really stops with him now. And so he, on the basis of what I've seen, there is a certain seriousness among decision makers on this particular area of danger to the public. What danger to the public, for those of you who have had some cases, and I should mention that all cases, all criminal rehabilitation cases at the lesser level, 19.2a, at the serious level, 19.1c, and all these danger cases for new situations that are going to the minister or the minister's delegate for opinion from anywhere in the world or in Canada cross my desk before they go on to that decision maker. That's where I fit into all of this. C-44 danger opinion by the minister or his delegate. It's not about time in Canada. It's not about a marriage to a Canadian citizen or community ties. It's not about rehabilitation, remorse, or punishment. It's not about 11th hour pleas or representations from members of parliaments. It's not about good intentions or clearing backlogs. It's not about money or jobs. It's simple. It's about removal from Canada of persons who, by their behavior, have demonstrated to the satisfaction of the minister or his delegate that they pose a risk. It's about a cultural change, I think, to some extent, or a reflection of a cultural change that's been ongoing in immigration, that says that there's a saying that if your dog won't come when you call him, you don't have a dog. And I would think that the cultural change reflects the fact that if you can't move somebody out of Canada who has committed serious offenses and poses somehow a danger to the public, you don't have a fully developed and operating immigration system. The cultural change is that there's emphasis now placed on the left side as well as on the right side. I think that this cultural change has been marked over a number of years and increasing. We're delegating authority for rather innocuous minor criminality, but also we're firming up on perhaps the criminality at the other end of the scale. The application of the danger provisions will force us to address removal issues as well, removal hesitations and difficulties with countries who don't seem to want to accept people. Well, because this isn't about a breached reg, this isn't about an officer's discretion or whether or not somebody can resettle in Canada, we're going to be forced to confront those removal issues with perhaps a little more vigor, because that's what this is about. It's about removal. And non-danger decisions, areas where cases are presented to the minister and he decides, or his delegate decides, that these people are not dangerous to the public, they will nonetheless be, as far as I understand, fairly vigorously pursued before the board. The final thing is that, as I mentioned, there is a centralized processing for this. You will get fair consistency, I think, in the application of these provisions, because there are a very, very limited number of decision makers, and they all come through one central office from anywhere in the world. Some innovations that we're picking up is that there are a number of danger provisions in the Immigration Act. There's 46 for refugee claimants, and there's Section 53 danger provisions for people who are convention refugees, and now this Section 75, etc. And we're trying to team them up so that in any case we deal with all of those issues in one package. I'll just leave it there, and if anybody has any questions, or perhaps David has any comments, I'll respond.
Well, I think we're going to need to have questions at the end after everybody gets a chance to leave if they want to. But Murray's got some phone numbers he wants to read.
I would
everybody, hey, look at that, huh? Pens, paper.
I would like to emphasize that my name is now Doreen Steidle, and I don't want to be held responsible for giving out these telephone numbers. Eastern European, or European Division, all of them area code 819-997-2448. Western Hemisphere Division, 819-997-1776. Asia Pacific, 819-997-2900. Africa and the Middle East, 819-997-3910. Facsimile, 819-994-8137. Hopefully they'll function as I'm trying to get my people to function in Buffalo. Send us a fax, and if we can write the answer on your fax and send it back to you, it might not look too elegant, but it gets you what you need, and we can go on from there.
Now, one last thing, if I may. As some of you know, I'm chair of the Canadian Bar Association Citizenship and Immigration section. We are co-sponsoring today's program with the Law Society. And since nobody else is going to thank them, of course I thank these gentlemen here for making the trip to impart their knowledge to you, but also I want to thank my partner, Howard Greenberg, and Marshall Drukarsh, the chairs of the program, because I can tell you that Howard at least spent the better part of a full week on preparing this for you, and I'm sure Marshall's done the same, so I want to thank them too.